Massachusetts Condominium has wonderful leverage when it comes to the collection of common area assessments. That is known as our beloved super lien, or the limited priority lien as it's called in Chapter 183A, Section 6. What that means is that the common fees, when unpaid, become a lien on the unit that jumps ahead of the first mortgage. Now, what does jump ahead of the first mortgage mean? For a period of 6 months, plus all legal fees incurred, the association's lien can, in fact, wipe out a first mortgage if the association should have to go to foreclosure. Foreclosure, some people say, you're going to sell my condominium unit because I didn't pay my common fees for 6 months? And my answer is, yes, we will do that. And that, my friends, is the greatest leverage that an association has. And I suggest to you that failure to properly use that leverage is doing a disservice to all the other unit owners who are timely paying their fees. Now, this is not done in the shadow of night. It's not done undercover. The unit owner gets ample notice that we are going to do this. The unit owner gets ample opportunity to pay the common fees and the attorney's fees that have been incurred. The unit owner gets ample notice to enter into a payment plan. There are many, many avenues open to a unit owner who hasn't paid the common fees. But the avenue that is there for the board to pursue is the enforcement of the statutory lien, which, as I previously said, if unpaid, can extinguish the mortgage. And the unit is then sold to a new buyer who takes free and clear of that mortgage. Now that is a tremendous, tremendous incentive for unit owners to pay, and it's an incentive for the first mortgage holder to pay, because the first mortgage holder can prevent a foreclosure by the association simply by paying the amounts that the unit owner owes. And that is why it's called a limited priority. Now, there are issues of timing to be considered. You may remember that I said 6 months. That is the period of the priority lien. So it's very important to first send out a statutory notice to the unit owner when the account is 60 days in arrears, or at the very least 90 days. And then that is followed by a series of letters that are sent to the mortgage holder advising them of what the board is going to do if this arrearage isn't paid. And if they want to protect their mortgage, they should step up to the plate. And in the substantial majority of times, that is exactly what happens. And by properly following these measures and adhering to the statute, boards have a strong right arm in addition to the right arm that they have, and they get the opportunity to keep their association financially stable.